Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And guys, we have some breaking stuff snuck in right under the buzzer on Friday afternoon. I'm about to show you how an assault weapons ban case just got accepted at the Fourth Circuit. That might sound familiar because we just talked about handgun licensure requirements in the same area. Everything will be linked in the description box below, and I can't wait to hear from you guys on this one. And of course, make sure you hit that like button, subscribe to the channel, and help the channel grow, and thank you so much for that consideration. All right, guys, listen, this has been quite a week for the Fourth Circuit. I did a story earlier this week around Maryland and how they are basically pushing the decision that the unconstitutional ruling for having a license to own a gun to the Fourth Circuit. The Fourth Circuit has decided to hear the case in full. Well, that's not all they decided to hear in full. Listen to this. This is breaking as of about an hour and a half, 2 hours ago. Legal alert, this is from FPC. 13 months after oral arguments before the three-judge panel, the Fourth Circuit says it is taking our lawsuit challenging Maryland's assault weapon ban in banc, which means it will be reheard before the entire court. Guys, this is a big deal. This is the assault weapons. So Maryland itself, the infringing state of Maryland, is now going to have licensure to own and assault weapons heard at the exact same time frame. I'm about to show you the time frame because they released it this spring. Guys, this is a big deal. I'm going to walk you through the entire ramifications, but this is breaking. Here it is right here. As you can see, filed 112 at the very top. This is the Bianchi case. If I go to the next one right here, here's the order. A majority of judges in regular active service and not disqualified having voted in a requested poll of the court to grant rehearing in banc. It is ordered that rehearing in banc is granted. Okay, this is really, really awesome because keep in mind, while this is occurring over here in Maryland, what am I always saying on this channel? What's going on in Illinois? What's going on in Washington? What's going on in California? California, assault weapons ban, constitutional, unconstitutional, seesaw back and forth. Washington, trying to do the same thing, particularly with mag bans. Illinois, assault weapons bans. Maryland, in the courts. Guys, are you seeing where this is going? Just saying, it's an acronym. They call it SCOTUS. Now, look at the time frames here. Case tentatively calendared for oral argument during the March 19th, March 22nd, 2024 argument session. That's coming this spring, guys. This is a big deal. Things like this don't happen that frequently, and the velocity of what we've had from the gun rights side of the cases is staggering over the last year and a half, 2 years. But here's the actual case in question, just so you know what we're talking about and what they're going to be hearing in March. Then I'm going to tie this whole thing together by zooming out. Baltimore, Maryland. This is from December 1, 2020. Today, Firearms Policy Coalition, FPC, announced the filing of a new federal Second Amendment lawsuit that seeks to strike down the state of Maryland's ban on so-called assault weapons, arms that are constitutionally protected under the Second Amendment. Yep, that's correct. And here's what they said in that filing, which now, down the road, 3 years, is going to be heard March 19th through 22nd of 2024. Quote, all individuals who are legally eligible to possess and acquire firearms have a fundamental constitutionally guaranteed right to keep common firearms for defense of self and family and for other lawful pursuits, the plaintiff's complaint says. Quote, but the state of Maryland has criminalized the possession and transportation of common firearms by ordinary citizens, making it wholly unlawful for law-abiding citizens to exercise their fundamental right to keep and bear such arms. Did you notice the trend there? Commonly owned, commonly used, commonly held, as in the Heller decision, common use. Everything that we're having bring forward right now, you've got the Heller decision, you have the Bruin decision, you have common use, you have Maryland, you have Illinois, you have California, you've got some Washington getting thrown in there. You have on the other side of the spectrum, you've got New Jersey, you've got New York. This is all heading in a direction that we've been wanting it to go for a while. The Seventh Circuit just said it's constitutional to ban ARs. What if the Fourth Circuit said it's unconstitutional? Guys, if that happens in March, that means the SCOTUS at their circuit level, right underneath them, has one circuit court saying it's lawful, one circuit court saying it's not. You want a real-life example of when that happened recently? The bump stock ban. The Fifth Circuit and the Sixth Circuit in disagreement, and the SCOTUS took the case, which we will hear this year. Guys, Our fight is real. Make sure you are subscribed. Make sure you are paying attention. Make sure you got that notification bell on, because this fight is just getting started and I can't wait to walk through this with you. Let me know what you guys think in the comments field, and I will see you on the next one.